Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hope you guys are having an amazing Saturday. Hey, so this is a Megan Thee Stallion versus Milagrogramz update. Milagro has filed a response to Megan's objection to Milagro's motion to dismiss. If you have not caught up on what has been going on in this case, definitely check out the playlist that I have. It will be a link to that at the end of this video. But without further ado, let's hop right on into it. As I said it before, there has been a lot of back and forth. You know, Megan's claiming defamation, cyber stalking, intentional infliction of emotional distress, harassment, you name it. Milagro, in her defense, she's like, hey, this is freedom of speech. Everything that I'm saying is just really an exaggeration. If you want to believe it, then that's you, blase. And then Megan is coming back like, hey, no, you can't claim all of this under, a hyperbole or freedom of speech, let alone you're not even a journalist. You claim yourself as an individual. Therefore, certain statutes don't apply to you. And then in the last pleading that was filed by Megan's attorney, there were they listed some discrepancies with Milagro's attorney in the little I don't want to say little motion to dismiss, but uh they were citing cases that really did not support the reasoning for wanting the First Amendment complaint actually dismissed. So I was very intrigued to see how Milagro's attorney was going to respond, and here we are. So let's hop right on into it. So here, I'm just gonna get it. All right. So the rebuttal of the matters raised in plaintiff's response. Once again, we're talking about defamation. So they're addressing the application of the Florida statute, section 770. So mind you, in the last pleading, there was Milagro for the simple fact Milagro is not a journalist. Has claimed herself as an individual. Plaintiff's argument that Florida statute section 770.01 does not apply to the defendant to legacy media such as radio, television, and newspapers. However, as noted recently by the recent presidential election results, bloggers and live streamers are now part of the media where many people of the public get their information and entertainment. Defendant, as alleged in the First Amendment complaint, is a blogger with over 100,000 followers who reports on various pop culture items, not just the plaintiff. As such, as noted by the authorities cited by defendant, she is entitled to pre-suit notice under Section 770.01. They cited Commons versus Converse. Let me see. This says plaintiff suggests that because she alleges that the defendant is on the payroll of Mr. Peterson, which is not true, this somehow disqualifies her from having to receive pre-suit notice under the statute. This argument is without merit. All media companies, even legacy media, receive monies through advertising, especially trade publications. Taking the plaintiff's argument to the ultimate conclusion, then, by virtue of receiving such monies, they would no longer be subject to the statute as well. Notably, this collusion conclusion is not supported by the plain language of the statute. Plaintiff's noncompliance therefore requires dismissal. Hmm. All right, let's get on to the next part. Defendant's comments about plaintiff's credibility at trial is pure opinion and protected under the First Amendment. Plaintiff takes the position that if someone does not parrot her preferred narrative, this constitutes defamation. In fact, plaintiff takes this even further by suggesting that even statements made by the defendant criticizing the police regarding the pow pow, bullet fragments, and DNA somehow is defamatory to her. This is not defamation nor actionable under Florida law. Plaintiff also makes the suspicious argument, not s- yeah, no, speculative, I'm sorry, argument that criticizing the credibility of a witness at trial, especially one that is a public figure, is tantamount to defamation. Plaintiff's argument is flawed because, again, it presumes that simply because the jury convicted Mr. Peterson, plaintiff's trial testimony is therefore incontestable. Further, plaintiff again misstates the fact in that the defendant has repeatedly criticized the credibility of the trial witness, plural, in the criminal trial, which is sensible given that one of the key witnesses, Ms. Harris, pled the Fifth Amendment and was given immunity, and given testimony that plaintiff and Ms. Harris were both intoxicated and could not remember certain facts, and given that plaintiff admitted that the incident that she didn't tell police she had been pow-powed, saying instead that she stepped on broken glass. It was only 4 days later, in an interview with Detective Stogner, the plaintiff claimed to have been pow pow. Further, plaintiff admitting to lying on national television about her relationship with Mr. Lanes. These are some of the items in the defendant's statements that form the basis of her opinion. Once again, the plaintiff's trial testimony cannot be proven to be true or false. It was up to the jury to believe her or disbelieve her along with the testimony of other witnesses. Thus, suggesting plaintiff was not a credible witness or that she was a liar does not ipso facto constitute an accusation of perjury or defamation per se. Calling an individual slow or retarded does not rise to the level of actionable defamation against a public individual. Plaintiff's suggestion that defendant asking an evaluating question about the plaintiff's mental status somehow rises to the level of defamation is non-sensual, non-cynical, sensical. Again, looking at the full context of the quote and the live stream video rather than edited portions, clearly the defendant noted that these were questions that should be asked of plaintiff. Let me read this. So, it okay. Megan said that he pointed a pow pow at her with the intent to harm her and that she was afraid for her life. How if Sean Kelly and if Jaquan Smith saw what they saw, and that deserves another trial off that alone? And I'm going to tell you something else that that MFing 911 call needs to be unsealed immediately because Sean Kelly called the police for an altercation that took place before pow pows were fired. I guarantee that we will hear everything play out on the phone. He was right on the balcony, right above their heads, effing, I mean, yeah, very effing close. Furthermore, babe, what is Megan's mental status? Does she have a guardian or not? Not it. Has she been listed as a capable person? Has she ever been deemed like legally retarded? Anything of that nature of the sort? Those are good questions. Megan Thee Stallion has a mug shot from a situation with a ex-boyfriend where she was arrested for domestic violence. Was she ever supposed to be in possession of a weapon? Could that the same color of a lot of ish that you wear, Little Miss Olive Green? I've question answered. I don't know if they this has to be a transcript from somewhere, but it doesn't make sense to enter. But anywho's, contrary to the plaintiff's contention that this court should disregard the entire post and look only at the four corners of the First Amendment complaint, it is axiomatic that when the video and post are linking in the pleading and the information at issue is part of what was shared in the videos and posting, as a result, the information is in the pleadings. They quoted Guerin and Menigazo, where it says, holding that when a video is referenced in a complaint and subsequent motions reference the video, information gathered from the video is part of the complaint and will not be struck. That's correct. That is correct. Given the context of this overreach to suggest that this statement is mentally incapacitated. Intentionally misstates defendant's 971, and they're referring plaintiff's reluctance to refer to the full statements and context of defendant's post and suggestion that the full post should be ignored in this matter is the reminiscence of the Wizard of Oz telling everyone to ignore the man behind the curtain. Plaintiff suggests that the statements in the defendant's October 29th, 2024 live stream refers to her when in fact they refer to a California-based reporter, that the cockeyed lady who happens to have the first same name as plaintiff, though different spelling, who has been and continues to covers plaintiff case in the media. This is clear from the full quote and context of the October 29th, 2024 statement. In context, the statement, which is a response to plaintiff's counsel document preservation letter, reads in parts as follows. And I know Megan, and I know who they're talking about. Megan is a journalist. I forgot what her last name is. It starts with a C, and she covers this. So I hope she doesn't feel bad after listening to that. This is crazy, but you do have to read everything in context. You can't just take bits and pieces out and draw a conclusion or make an inference to that. You have to look at it as a whole so that way you can understand before you make draw your conclusion or make an inference about it. So here is what it states. So let me explain something to you. Alex Spiro didn't have nothing to do with that trial. Why are you sitting up here telling us where a pow pow is supposed to be? You ain't even making no sense, sir. And guess what? Since you said it is available either way you spin it, it's a problem. If it is missing, that's a problem. If it is not missing, why was his side wait, why has his side, they saw side, been under the impression that it cannot be retested and that it's not available for testing? So what? What's going on here? Those are the questions that you have to ask. So I feel like they're trying to control the narrative. I feel like this is a scare tactic. I feel like they do. They don't want you to discussing these things, and I firmly believe that they didn't think it would get this far. We wouldn't even be having this conversation had they rejected everything. And then you go on social media and the cockeyed lady that says she's seen Megan, she's online telling you he has no chance. Everything's going to get rejected. How the hell it baffles me how people beat jail time and want to come up with an act like they own a dang high horse. You ought to be somewhere for your alleged crimes. Drunkie, why do you even speak? Like, does your liver even function? Well, you have so many different things going on with you. I don't get it, but whatever. So, cha, it's a whole bunch of he say, she say. I think that they're upset. They said that all of this is coming out because Megan's documentary is coming out, baby. The universe did this. As noted by authorities cited by defendant at pages 9 and 10 of her motion to dismiss, the above statement is not defamatory. It's pure opinion, hyperbole, or at worst, this is not actionable defamation against a public figure. All right, Alice. In her papers, the plaintiff suggests that the purpose of this motion to dismiss malice needs only to be generally pled. Malice by citing the negligence standard for a private individual rather than a higher, clear, and convincing standard for a public figure. And secondly, her suggestion that conclusory statements are sufficient will not carry the day. As noted by the 11th Circuit, this court held previously that the Twombly Iqbal plausibility pleading standard applies to actual malice standard in defamation proceedings. Thus, to plead actual malice, the plaintiff must must allege facts sufficient to give rise to a reasonable inference that false statement was made with knowledge that it was false or with reckless disregard of whether it's false or not. This is a substantive test focusing on whether the defendant actually entertained serious doubts as to the veracity of the published account or was highly aware that the account was probably false. Man, oh man, oh man. They cited Turner versus Wells, holding in action for defamation against a public figure and affirming grant motion to dismiss. Yeah. All right, he came back. I give Milagros attorney some points. Florida Statute 836.13 violates the First and 14th Amendment and runs afoul of plain text of the statute. No matter how the plaintiff wishes to spin the facts, the reality is that count two is buttressed on the mere facts. One, the liking of third party online posts containing a deep fake video. Two, speaking out the deep fake video in a live stream and uh, intimating that the video is likely a deep fake. And three, posting go to my likes so that others can see what she is discussing in the live stream. This does not fall within the narrow definition of promote under Florida statute section 836.13. Plaintiff also misstates the record where she states that the defendant shared the video on her profile. She did not. She simply pressed the like button on a third party post. She did not repost it. Notably, plaintiff ignores the case law cited by defendant, which states that in Florida, statutes like these must be narrowly construed in favor of the defendant and against the plaintiff. The silence is deafening. Clearly, to interpret the statute as broadly as plaintiffs suggest would violate the First Amendment as an overbroad content based restriction. So in U.S. versus Alvarez, it stated holding that the Stolen Valor Act is unconstitutional under the First Amendment. All right, so let's see. So, and that was an issue. Now I understood where Megan's attorney was coming from because even though you said that you did not share it, when you hit like, it still posted to your page, but just under a different section. Eh, I'm on I'm not gonna lie, I'm on the fence with this one because it's just like, and that was back in the Twitter days. So it when you hit like, you like the video, it's posted to your like section, which anybody can access, and then they can go and they can like it and retweet it or however you do that on Twitter or X. So I do understand that, but then on the flip side, I do understand where Milagros attorney is coming from as well. All right, so as noted in the Florida Senate's Bill Analysis and Fiscal Impact Statement Bill, Senate Bill 1798, it states currently, no states completely ban the creation or distribution of all deep fakes. A complete ban of such things would likely run afoul to constitutional protections under the First Amendment. However, certain categories of speech, including defamation, fraud, true threats, and an intimate and likely incitement of violence do not receive protections under the First Amendment. Some deepfakes will likely fall into one of those categories and therefore may be regulated. In light of the above commentary, coupled with the statute's narrow definition of promote, it is clear that the conduct the statute was intended to cover does not cover the allegations that Megan stated in her First Amendment complaint. Furthermore, the allegations in that First Amendment complaint also fails to tell the whole story, as to demonstrated by her cherry picking portions of the defendant online post. Accordingly, to assist the court, this defendant has filed a supplement to the appendix transcripts of her live streams, which show the full context of what she said on June 8th, and that was attached. And I do agree with this here because I've always stated in order to understand something, you have to actually read it in these students, the adult learners. So you have to read it in its entirety and get the full context before one thing that Megan did state in the last pleading, her opposition to that, is that the transcript, so it really didn't give, it was some stuff that they said, but I understand now. So now Milagro has provided additional transcripts of the live streams in its entirety so they can understand exactly what was said. All the defendant did was report on something that was sent to her while she was on live stream, well, while she was live streaming. There are no allegations in the First Amendment complaint that the defendant's conduct in discussing the video, hitting the like button on someone's post, or posting "go to my likes" would fall into the categories of defamation, fraud, true threats, or the imminent and likely excitement of violence. In this day and age when celebrities and influencers themselves release X videos for publicity, the defendant reviewed it and concluded it was in all likelihood a fake and suggested Miss Pete sue the perpetrator, and that she did. And I'm talking about Milagro. She did say that. She did not promote it within the meaning of the statute. The one who did was an individual who created it. Once again, the plaintiff is looking to criminalize protected speech under the First Amendment to censor the defendant. At worst, the matter is mute as the posts were taken down. Thus, count two of the First Amendment complaint, which is the deep fake, should be dismissed with prejudice, and any amendment would be futile. Plaintiff has cited no authority to plausible support her claim for intentional infliction of emotional distress. Plaintiff's opposition papers suggest that the claims for intentional infliction of emotional distress cannot be determined at the motion to dismiss stage. This suggestion is without merit and ignores the panoply of um, cases cited in defendant's motion to dismiss. Further, her reliance on Albert versus National Cash Registry Company is of no help to her as it relies on the pre Trumbull Iqbal standard of review and does not take into consideration binding case law in this district. Furthermore, plaintiff completely ignores all the decisions cited by defendant, which shows that there can be no emotion IIED, I'm just going to do the abbreviations, claim in the absence of serious violent crimes or actions, essay, or unaliving, and that claims for IIED are routinely dismissed in Florida at the motion to dismiss stage. Mm-mm-mm. Oh, let me see. Furthermore, undermining her position is plaintiff's reliance on the East. What is that? I think that's the state of Duckett, and it quotes. It says, which involves a wrongful unaliving case and relies on one aspect of the Florida law that is applicable here. So even her attorney at Quinn Emanuel is quoting a case that is not really applicable in this case because it is a wrongful unaliving case. As it stands, Florida courts have shown a particular solitude for the emotional vulnerability for behavior toward a unalived body, or deference to family feelings where rights involving um, unalived bodies. Megan's attorney quoted a case that is not even relevant to this case to support whatever your claims are. You have to cite case cited a case that is a wrongful death case. They should have decided a case that, the now they did a good job in the pleading because they was, but once again, you can't apply this particular statute to that because mhm. It goes on to say that, let me see. Likewise, the court's decision in Gallagly versus Rodriguez provides Ms. Pete no refuge as this case dealt with egregious police misconduct where there were allegations of a police officer engaging in heinous acts of extortion against the plaintiff by conducting a continuing campaign of harassment by running a rug and prostitution ring out of the bottle club and refusing to investigate illegal activities inside or associated with the bottle club while harassing plaintiff and his employees to ensure their silence. So the case that, once again, here's another case that Megan's attorney cited. However, it would not apply to this case because they're two separate things that happen. Megan's case is very, very different than the case that they cited just now. It says, in fact, the district court in Gomez versus United States in distinguishing Gallagly granted a motion to dismiss an intentional infliction of emotional distress claim where the allegations were more egregious than the mere name plaintiff alleged that the Customs of Border Protection officers confronted plaintiff's mother and yelled object choked him and slammed him against a vehicle. And then, after inquiring as to the plaintiff and told him that he would be raped by black men while he was in jail. All right, so that, yeah, that is on no level. That is like way, way up there. That's way, way up there. So you definitely can't compare Megan's case to what this officer said. No way. Clearly, these allegations are more severe and is than what is alleged here. And despite that there were actual physical touchings in Gomez, Judge Moore held that the use of force was a de minimis and that the grape remark was distasteful, was not repeated on multiple occasions, was not a direct threat, and therefore failed to state a plausible claim for IIED, thereby dismissing the court with prejudice. Did y'all see that? So even the court, y'all saw how egregious the statements were made by this police officer. But even though it was distasteful and it wasn't repeated on multiple occasions and it wasn't a threat, a direct threat, it didn't, it didn't constitute as a plausible claim. And the court dismissed that court proceeding. So if this is what we just heard is very, very severe, it's like this is at 100 and Megan is at 10 at the lowest. So if they can dismiss that 100, what do you think they're going to do to this case? Ooh, ooh, ooh. Notably, plaintiff has not and cannot point to any case supporting her claim for infliction of emotional distress. Accordingly, count 3 of the federal, not the federal, the First Amendment complaint should be dismissed with prejudice, as once again, any amendment at this point would be futile. The last claim was plausible. Uh, let me see. Count 4 fails to plausibly state a claim for cyber stalking. There we go. Despite the plaintiff's spin to suggest that she states a claim for cyber stalking, what she really is seeking is an injunction to censor the defendant from uttering statements she disagrees with. Notably, her response fails to address the authorities cited by the defendant, which unequivocally hold that in Florida, injunctions are not available to stop someone from uttering insults or falsehoods, or for that matter, misinformation. Further reliance on Strober versus Harrison is unveiling. First, that decision does not involve a public figure. Second, the allegations in this matter once again pale in comparison to those in Struber, where it was alleged that the defendant had directly issued threats against the plaintiff and incited threats from her viewers, falsely accused the plaintiff of child abuse, announced her home address online to his viewers, and published a photograph of her minor daughter. Some of these threats included outright death threats or unaliving threats, pictures of mutilated and dismembered human bodies, a picture of a young black woman in a casket, photos edited to show plaintiff hanging from a tree, the home address of plaintiff and others of her family. Five, a picture of a location near plaintiff's home with a message, "See you soon." Moreover, the court did not hold that the allegation stated a claim under the same statute. Rather, the case was reversed because the court failed to apply the full statutory definition of cyberstalk in its definition and held that there was no personal jurisdiction over the claim. The court thus reversed and remanded so that the trial court could reconsider the evidence under the correct statutory standard. Again, in the case sub judice, there are no allegations here of any death threats or threats of violence, or are there any allegations that the defendant incited such threats from her viewers or listeners? That's a point. Again, it's perverse that the plaintiff would waste the resources of this federal court in seeking an injunction to censor defendant because she allegedly called plaintiff a lying a hole and like illegally retarded or a junkie. The First Amendment prohibits such restraints through the use of injunctive relief. Accordingly, should the court invoke supplemental jurisdictions over count 4, it should be dismissed. It should dismiss the claim with prejudice for its failure to plausibly state a claim under Section 784.0485 of the Florida statutes. Finally, in her opposition papers, plaintiff suggests this court has no discretion under Title 28 of the United States Code, Section 1367 C4, to decline jurisdiction over the cyberstalking claim. Again, plaintiff is wrong. It is clear that count 4, which seeks purely injunctive relief under a Florida statute, is brought pursuant to Section 1367, given that it is not a claim for monetary damages. Diversity jurisdiction exists in this matter solely on her allegations that her damages are under her state tort claims, which exceed $75,000. First Amendment complaint itself invokes that the court's supplemental jurisdiction under Section 1367. Accordingly, this flies in the face of her argument that defendant's presumption that the claim is brought pursuant to the court's and that it has discretion to dismiss is wrong. Pursuant to Title 28 United States Code Section 1367, and as such, this court has discretion to decline supplemental jurisdiction based on a well-reasoned opinions by Judge Welthorel. What? Yeah, good googly moogly. Plaintiffs and two. Plaintiff's response does not dispute that she has no legal basis for attorney fees in counts 1, 3, or 4. She merely argues that it is premature to dismiss and or strike these claims. However, the court need not wait until plaintiff files a motion for attorney fees to rule on the instant motion seeking to strike the fee reference asserted in counts 1, 3, and 4 because has already conceded there is no statutory fees under those counts. In conclusion, this case is emblematic of rich celebrities are using the courts and their financial means these days to silence the critics by do not have the resources to defend these cases, hope and intent that be defaulted or go bankrupt. Plaintiff takes this weaponization of the court system a step further by bringing a federal action for such nonsense critical opinions and commentary by defendants describe her song lyrics in trial testimony and in her recently publicized documentary. This is why defamation cases like this as there is a powerful ensuring that free speech is not unduly burdened by the expensive yet groundless litigation. Plaintiff further suggests that the defendant should be censored and penalized because this were correct. This is this does not obviate the protections of the First Amendment. Provides the First Amendment. Mm. Um, as noted by Justice Kennedy and Alvarez, excuse me, the nation well knows that one of the costs of the First Amendment is that it protects the speech. Though few might find respondents' statements anything but contemptible, his rights to guarantee of freedom of speech and expression. Finally, plaintiffs suggesting that a guilty verdict in a criminal case precludes those like defendant from criticizing witness credibility while the case was handling is chilling. There are no safe spaces in the real world. This is the business they have chosen. As Justice Branch exposed through discussion, the falsehood and fallacies to a remedy to be applied is more speech, not enforced silence. Perhaps plaintiff, who is a new resident to the state of Florida, should read about Florida's dark history where the Groveland Four were convicted based on patently false and coerced testimony and racial bias. Just because a jury convicts a defendant does not mean that the state's case was and should be deemed the gospel, and that those speaking out against the conviction should be condemned as heretics. If this was the case, accordingly, based on the foregoing and on the grounds set forth in the motion to dismiss, defendant respectfully requests that plaintiffs first this court deems it appropriate. Defendant respectfully requests pursuant to Rule 12 of the Federal Rules of Civil Procedure that this court convert this motion into a motion for a summary judgment. Ooh wee. And this was submitted on the 17th. Y'all, now, I love Megan's music. I truly do. But when you are dealing with law, you use law and you cite cases to defend your claims. I must admit that Milagros' attorney did absolutely outstanding on this pleading. Um, I, I'm blown away. I am very blown away because I absolutely agree with everything that is stated in this pleading. Um, you know, Once again, they cited, so for instance, defamation, they cited cases that were more severe than even Megan's case, and yet it was dismissed because it didn't make a plausible claim. defamation or a plausible claim for intentional infliction of emotional distress. And they cited some pretty severe cases where their case was dismissed because they failed to state a claim. You cannot cite, if this is a defamation case, right? You can't be citing a wrongful uh unalived case. They were talking about unalived people. Here you claim that they were talking about you in a defamatory matter. Yet that case was dismissed because they said it wasn't a direct threat. And so this is a good one. I'm very interested on what the court is going to have to say, because let me see, because this is they still hear the motion to dismiss. So normally, you file the motion to dismiss, file your reply to it, and that's what just happened. So now, more than likely, I got to see when they will actually hear this case, and the judge is going to review both the replies, the objections, as well as the motion to make their determination on what to do in this case. They're going to see they're going to interpret, did Megan the Stallion actually prove her claims? And that's it, that's all. Y'all tell me how y'all think this case is going to play out. Now, I know Megan was granted with her restraining order. However, this is a whole different ball game. You're making claims for defamation and cyber stalking and intentional infliction of emotional distress, but we have to look at the law. We have to look at the law. Y'all tell me what y'all think is going to happen in this case. Do y'all think this case will be dismissed? Will this be a win for Milagro? Put it in your comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed and have an awesome Saturday. Bye.